As a court pleases, my lord, just before Advocate Numalo starts with his cross-examination, just two brief points. The first one, my lord, refers to some logistical arrangements. One of the court officials, Mr. Jonas, is not available after lunch. He's got to sit on the shortlisting panel.
Oh, I see.
For an interpreter, and the session commences at 14:30.
Okay.
14:30, and he says, my lord, he couldn't get a replacement. So we might be constrained to sit until about 2:15 or so this afternoon.
And then what happens to the lunch hour?
Well, the accused are entitled to a meal break.
Yeah.
So we will have to still adjourn at 1 and then resume at 2, just briefly, and then adjourn.
Okay, fine. I mean, it's
If
part of his duties.
yes.
So there's nothing the court can do but to support that arrangement.
Then the second point, my lord, just to correct the record.
Yeah.
Yesterday, Advocate Mnisi put it to Brigadier Gininda
Yeah.
that he was not being candid with the court when he answered to his question that the section 2.5
Yes.
of accused number 3 for the number 07276686169 covering the period when the offense was committed,
Yeah.
when he testified that this information, the section 2.5 for that period covering October 2014,
No, not available.
was made available to him fairly recently.
Yeah.
When this trial was underway.
Yeah.
We maintained yesterday, my lord, that Advocate Mnisi is mistaken, and we say this with the greatest of respect. We mentioned that this information became available just before Ms. Faithillingham testified,
Yes.
and we have had a look at the record. On the 15th of May 2024, on page 1 of the record, line 18, we address the court as follows. Then, when we adjourned at the previous occasion, we indicated that we have received the call-related data of accused 3, which we then shared with our colleagues. That Colonel Hose then went and compiled a further affidavit arising from the call data of accused number 3, and that that morning of the 15th of May, we had finished the additional statement of Colonel Hose. And when we look, and there are emails available between us and Ms. Faithillingham on the 8th of May 2024, wherein we request the call-related data of accused number 3.
Yeah, just put that on record because Mr. Mnisi says you gave that information long time ago when he was preparing for the case, meaning before July last year.
Yeah, on the 8th of May 2024, Dr. Sibanda writes an email to me asking that Ms. Faithillingham should forward to the section 2.5 of Gadlan Nube number 072-766-8169, and saying he wants to, or that we need to zoom in on the movements of accused number 3 on the 26th of October 2014. I then sent on the same day, 8 May 2024, an email to Ms. Pinkified Thillingham, and asking her to share the section 25 or call-related data of Nube accused number 3, so that we can scrutinize his movement at the time of the commission of the offense. As I say, this is all happening on the 8th of May 2024, and we have the emails to prove that. Then we mentioned yesterday that Exhibit G1 covers the period, and this we see on the cover page of Exhibit G1. It says the nature of the information required. This is now the, it's a subpoena in terms of Section 205 that is addressed to Vodacom. It is mentioned by the investigating officer in that case on the 5th of March 2015. He says the nature of the information required from Vodacom is as follows. It says the MSISDN profile, RICA ownership information, tower information, IMEI profile and billing from 23 October 2014 to 25 January 2015 of this number 072-766-8169. This is now the period that Brigadier Gininda mentioned that we did not have information for this specific period, and for which he was then labeled as being, and I'm not going to repeat the word, but implying that he's less than candid with the court. Further on, in Exhibit G1, there's an affidavit of Ms. Thillingham, wherein she states in paragraph 7, this certifies that Vodacom has received a subpoena in terms of Section 25 from the South African Police Service, and she gives the reference number GP JHB for Johannesburg 50/3/2015, Phosphorus CAS 103/12/2014, and the investigating officer is Constable Dlamini. Then when we look at Exhibit D in brackets 5C, this is now the affidavit of Lieutenant Colonel Halls, that he had to amend after receiving this additional information as per Exhibit G in brackets 1. This we see in Exhibit DD5 in bracket C, paragraph 3. He says on 8 May 2024, this is now the date to which email correspondence between us and Ms. Thillingham refers. And he says, I was contacted by Brigadier Gininda from Cold Case Unit to assist on the analysis of Section 25 of Phosphorus CAS 63610/2014. And he says, on 9 May 2024, I received a sealed forensic bag with seal number PA 5001309-432 from Sergeant Mohola Mark Fosslores 63610/2014 murder. The bag was not opened and or tampered with. And he says he opened the forensic bag and it had 2 DVDs marked Johannesburg 50/3/2015. This is the reference, my lord, that appears on Exhibit Triple G1.
Yeah.
And he says the intention and scope of this analysis and request from the investigator was to determine the following: if there were any communication between this number of accused number 3072766869 and the other accused before court. So in brief, Lieutenant Colonel Ho says he received this additional information, as a result of which he then had to amend his affidavit. We therefore submit, my lord, that the very serious assertion that Advocate Mnisi made against Brigadier Geninda was unfounded and unjustified, and we submit, my lord, that that assertion ought to be withdrawn. As the court pleases.
Yes, Mr. Mnisi.
As it is the court, my lord. My lord, if I were state, I would actually not be pursuing this line of argument, because simply it exposes the inefficiency in the nature of the investigation in this case. And I'm going to request the court to listen to me as it did when the state was making their own submission. Number one, the reason why I'm saying that, my lord, in 2015, accused number one's phone gets confiscated. Subsequent thereto, they are able to get some downloads from his phone. Same phone that is confiscated in 2015. In 2020, accused number 3 and others get arrested. This case, it's got an investigating officer, a team of investigating officers that are assisted by prosecutors. None of those members having it in their mind that, look, because in 2015, accused number 3's phone was confiscated when we were able to get some downloads in the very same phone. When they were investigating this case, we were able to get some downloads in this phone which talk about the date of the 26th of October 2014. Let us also check his movement or the movement of his phone on that particular day through the section 205. They don't do that, my lord. Now they want to make a meal out of the fact that I've said that this information was made available even before the inception of the trial. That is not the point. The point has got to do with the quality of investigation of this case. But as I'm saying, if I prosecute, I will not be pursuing that argument, my lord. But nonetheless, as to whether or not that information was received at the inception of the trial or later on through the testimony of Mrs. Vittilingam, is neither here nor there. What is important is what is contained in that section 205. Because whether it was made available at the inception of the trial or it is made available through the testimony of Mrs. Vittilingam where the matter has already started, I don't think the information would have changed. That is all that this court needs to decide on whether that information bears some kind of relevance insofar as accused person's involvement, accused number 3's involvement in this case is concerned, my lord. All these other issues are just collateral issues which will actually not assist this court in the determination that this court will want to, that this court needs to do, my lord. Thank you very much.
Advocate Mnisi cannot run away from this simple fact, and is trying to distract from the real issues. He made this very serious allegation yesterday when it's not about the investigation at all. Brigadier Geninda testified yesterday that he received Exhibit Triple G1 fairly recently when this trial was underway, and Advocate Mnisi then branded him. The term that he used is dishonest. Now, we are showing that he's incorrect in that regard. Now, instead of just accepting that as far as that narrow aspect is concerned, he might have been mistaken. This information was not made available then. The only information that was made available at the time, as we made the point yesterday, was data from the 14th of November 2014. And Brigadier Gininda testified that they did try to get hold of the call-related data for accused number 3, but that they were given only call-related data from the 14th of November 2014, and we have submitted proof in this regard, and that is the information on which Colonel Stein
House.
Stein.
Oh, Stein,
Yeah, Stein based his, his affidavit on. Now, yesterday, Advocate Mnisi undertook to go to his chambers and to find this exhibit G1. He came back and said he couldn't find it. Now, all we are saying, my lord, is that it was unfair and uncalled for to brand Brigadier Gininda as being dishonest when all this information indicates that indeed this information was obtained after the 8th of May 2024. That is the crux of the matter.
So, Mr. Mnisi, you don't admit that you made a mistake by branding the brigadier as incorrect when he said he only found the section 205 of accused number 3 at the time, just after Ms. Pingy Bellingham had testified or was testifying.
I'm not so sure whether, my lord, whether I use the word incorrect.
Okay, fine. We're going to waste time. The court apologizes for you on any judgment which was said to have been cast on you that you are dishonest in making that statement. Okay? Right, let's begin. Yes,